It is seen from the order of this commission dated 99/2024 that in the draft conveyance deed forwarded by the OP to the decree holder, a precondition has been mentioned requiring the complainant to withdraw the complaint before this commission, as well as not to press any relief that has already been granted, which is contiguous in nature. But this is the difficulty, my lord. The builder is not transferring to the home buyer and the landowner is stuck in between, my lord. We have already given a GPA under the JDA. They have used it to transfer it to N number of buyers. For some reason, my lord, they are not transferring it to these 10 people.
The moment we say that they are jointly and severally,
And for some reason, they're not.
The problem will be solved after hearing you, if we are going to hold that you have joint and several liability. So then you will resolve the issue between you and the builder separately and whichever manner permissible.
Not even without coming to the aspect of liability.
As the consumer is concerned, he will have the remedy as against both.
Not even without.
And between you two,
I understand.
consumer rights can't be defeated.
That is very true. There is no, and not for a moment am I saying that they don't have a grievance, my lord. But what is my role? I've given the GPA, my lord. Today, if the builder wants, he can transfer it. What can I do, my lord? That is my problem. I am also a victim. Okay. And regarding, my lord, the submission that whether I am jointly liable or not, that is a separate point, my lord. For resolving title, there is nothing more needs to be done than for the builder to give an undertaking that he'll do it after he receives his due monies or whatever is his concern, my lord. He can explain. As regards the liability, my lord, I'll address, my lord. I'll take 20 to 25 minutes to address on that point.
We should. There's an important.
Deeply obliged. My lords, may hear me on the point of liability then.
We will confine only to the question of whether it's joint or several.
But there will be consequences because they will be demanding compensation again from me also.
Listen, you will have a right. You contested the matter before the NCDRC. That's what the first question you were asking. So if we hold that there is joint and several liability, then you will definitely have a right to challenge the NCDRC's order, whichever is the forum. So therefore, that right to appeal against that order will always be there, and there can't be a execution straight away. We'll give you some time to file an appeal. This appeal will be heard. If you succeed, matter ends there.
But I've already been absolved by the NCDRC. Why will I go back to the NCDRC?
You have not been absolved. You have. No, we are not sending you to NCDRC.
Okay. Just one final point, Lordship. In my 2-page note, I have referred to 5 decisions of this honorable court, which has held that the landowner is liable, and I have also quoted 5 clauses from the agreement.
You can give your 2-page written submission.
Pardon me, Lord?
You can give a 2-page written submission.
I'll do that, Lord. And one more thing, Lord.
By this weekend, you give it.
The only issue is the title, my lord. The title can be resolved today itself. Why the builder is standing here, Lord? He's not saying anything, and I'm having to answer, Lord.
There's one sentence.
I am not getting
possession.
I am not getting possession. I am
My
not
lord,
getting
one
title.
sentence.
4 have paid 100%. There is a delay of 9 years, Lordship, and he has purchased from the home buyers have taken home loans.
We were intending to include you as a necessary party, but you want to resolve all these issues. You can sit down and then make a settlement and make him the payment. Matter should end there.
Lord, it's for the builder to do. I don't owe him anything. I don't owe him anything, my lord. He's paid the builder. He's got the flats to the builder.
Submissions
I'll file it in submission. Lordship, on the point of liability. Submission, I will also file one more, or this will.
No, nothing.
Lordship, deeply obliged.
Thank you.
Actually, they were a party and they have been absolved.
All right.
They are not transferring title.
My lords, your lordships are disposing of the matter.
We'll protect you. Don't worry. To file an appeal.
My lords, your lordships are disposing of the matter.
No. We are passing orders. Final orders.
Then one sentence, may not one important.
Sure. Tell us.
Main appeal was pending, which was passed by a single technical member. If it is allowed, whatever the exercise your lordships are doing and spending time, then it will become a futile exercise.
No, he's not being
futile exercise. That's
your lordships have already passed an order in this case. Doctrine of merger applies. Please see the judgment on doctrine of merger.
There is no chance to reject.
1 minute. What happened is that single member.
Lordship, one final point on the single. Recently, your Lordships interfered with a single technical member judgment on merits. May I just hand over the
You know
judgment?
that, Mr.
Experience
You are
developer.
in too much tension today.
Actually, they are not getting the
position.
position.
On to us also.
Builder is saying, you withdraw only, then you will get the possession.
That can be, we have also done, that can be done in a case where the solitary matter is before us. Today, against the same judgment, as Mr. Sagar is correctly saying, against the very same judgment.
No. He has not appealed. He has not preferred appeal against the review order. He is being economical with the truth.
Main order?
My lord, I have a
Main-
copy of the order.
main
right?
order, but
Clarify
he
it.
has not challenged the review
the
order,
judgment.
which is under challenge here. And Lordship, your Lordships have already passed a remand order in
Lord,
this
we see
case.
the order. It will clarify
Doctrine
everything.
of- Please see the judgment on doctrine of merger. After your Lordship has intervened and your Lordships have passed a remand order, Lordship may kindly see this. Please see this judgment on doctrine of merger. Just one para.
Pre-judge bench, my lord.
May I just show
We
this?
understood.
Lordship, please.
Right. All the next, please.
My lord, written submissions to be filed within 2 days.
Yes. Week, 1 week, not 2 weeks, by Monday.
One week, my lord. I was assuming
Monday,
2 days.
Monday.
I'll file by Monday.
By Monday.
Grateful, my lord. I'll file by Monday.
Yes, 2 days.
My lords, item 15, I'm seeking some time, my lords. I've only been able to contact my client yesterday. I need some time for instructions, my lords.
All right.
2 weeks, my lords. Obliged.
16. थोड़ा slow चल रहा है गाड़ी.
Item 16.
Yes. Customs inspector.
My lord's learned ASG is on her legs in court number 16 for item 11. I'm seeking a short passover.
Lord, the last 4 occasions passover was short, my lord, then subsequently want of short of time the matter is adjourned.
Yes.
And they keep on issuing DPCs, my lord, for accommodating the junior officers, my lord. Recently also, my lord, they have issued it.
That Pankaj Jain judgment, right?
Yes, my lord.
Pankaj Nayan. Pankaj
That is
Nayan.
really unfair.
They have not filed rejoinder, my lord.
There is nothing in this.
My lords may then fix
The
it.
judgment has clarified so many times.
My lords may.
We will dismiss this.
My lords may then fix it at after
Well,
lunch.
ask her to come online. We see.
My lord, she's on her legs in court number 16. I'll just a short.
My lord, that judgment of Pankaj Nayan,
No, my lords, we've also filed an application showing how they are conducting DPCs after
What
DPCs.
to do?
They are starting.
You tell us. Tell us.
My lords, this matter relates to OM dated of 1955.
But how? See, one short question is when your OM of 25/3/1996 is operating, which says that if a junior gets promotion, a senior's obligation to put in 8 years is not necessary. 2 years is sufficient. Then in which case all of them have passed more than 8 years now. How can you prevent him from getting?
My lord
and
said-
my lord, the
Just because-
department issued a letter. I'm sorry.
But my lords, it's a policy decision on our part. We can
That policy can't be
fix the
changed
date.
by OM.
We have
You
just
can't,
fixed
you
the
can't
date
through an administrative
from
instruction.
when and
change
how
it.
it will be applicable.
Dismiss. Dismiss.
I'm
My lords, may then
They are dismissing it.
For the impleaders, my impleadment has been allowed. Respondent number 21.
You are opposing, you are supporting the state.
My lords, I'm on the same side. I'm similarly situated as.
The respondents.
20. Just one submission that the High Court order, the impleadment order, we have also applied yours. Our impleadment has been allowed. Yeah,
Okay.
exactly.
Once we have dismissed this, it will automatically apply. to you.
Correct.
Just we were not there.
Doesn't matter. The law will apply to you.
The judgment. How can that
It can't be. No, it can't be. Can't be. Can't be. We can't say that that will apply.
I'm
Maybe
sorry.
request one more thing, Lord. It may be
We
directed.
will allow
Lord.
your applications.
Yes, my lord.
Yes.
Time-bound
Let's-
program. Lord, some time-bound direction may be given
All
for
right.
implementation of order.
Next.
my lords,
Whole batch.
My lord, this is a batch. Matters have been added on. Pleadings have to be completed. I'm requesting for time.
Lordships, on the last date of hearing, when it was listed, we had pointed out, Lordships, that the similar cases have been dismissed also. For that,
That must
for
have
that,
been by
Lordships had
mistake.
listed it. Court Master, please. Sabha Simran also, I have a copy. I have shared, my friends are also carrying certain orders, your lordships. This is a second set. Please have it. Court Master. आप अपनी वाली की
My lords, there are conflicting views.
Might have been one or two orders which would have been dismissed in the fact of the case.
And my lords,
In
in
addition, to
one
that,
matter,
there's
there's,
a notification of the union.
One minute, Mr. Vikas.
my lords, there are
There's also a
conflicting
judgment,
views.
is it?
Some matters are, notice has been issued, some matters have been dismissed. The whole matter is under consideration, my lords.
Aarke Agarwal, Justice Aarke Agarwal, Thada?
My friend must have given lordships. I have shared
My lord,
Sabha Simran and Shubhangi Gupta.
And my lord, I have submitted Pushpa Lekumul Tolani, DRI, Directorate of Revenue Intelligence. Pushpa Lekumul.
Yes, I have that list.
Has been referred to in the impugned judgments of the High Court.
दीजिए वो दीजिए
No, no, the notice issued matters are being under consideration. Take out Nidhi Kapoor SLP papers, a notice. Just give me the SLP number.
These are all diary numbers of the.
ये गवर्नमेंट का नोटिफिकेशन भी है वो पॉइंट
There are more matters, my lords. In fact, there is a conflicting view of the Delhi High Court itself. The Madras High Court has taken a different view. From the conflicting view, there is an SLP pending by the party, which has also notices being issued. There are contrary views.
Make a tabulated form.
We'll make a tabulated statement.
That have reached our court.
Yes, my lords.
We have all the matters which have reached our court. We have noted that in some cases, another benches have dismissed the matter.
My lords,
Despite
and
that you don't bring this to the notice of the court which is issuing notice. And you show the other order where the notice has been issued.
my lords, there are conflicting orders over here.
All right, you make a statement.
We'll make a list. Moreover, may I submit?
There's a
May I
notification
submit,
of the
my lords?
union.
May I submit?
Okay, you get all that ready. We will hear you after 2 weeks.
My
or
lords.
3 weeks.
My
It
lords.
shows that we will take a prima facie admission
What-
view in the matter.
One submission, my lords. As of here, the Delhi High Court had also asked the department to look into these issues. Some regulations have come out in February. The matter is under discussion for a policy decision. Therefore, I'm requesting my lords may keep
In-
it after 2 months.
In the matters in which we have issued notice,
Yes, my
in
lords.
none of them there is an interim order.
There are interim orders. There is stay orders. That is there. But in most of those cases, there is a,
Just one.
my lords, there are 20 matters to
May I,
deal.
may I only bring one more thing to your kind attention, lordships? Lordships, may
4 weeks, please get a tabulated
lords.
form of all the pending matters.
My
We will
lords.
see how proportionate it is. If it is high amounts are there, we will perhaps vacate the interim order and then we'll pass on.
Please, my lords.
Just after 4
May
weeks.
I only bring one more
Also-
thing to your notice, Lords? There's a notification of the union which provides the minimum threshold for appeals before this court, which is 2 crores.
You know that.
In all these cases, this is less than 2 crores.
Just check that up.
Lordships.
My lords, this is a matter of, this is not a matter
Not
of
stayed.
tax.
We have not stayed. If they have not stayed, not stayed.
Your lordships, in impugned order, it was mentioned that jewelry shall not be melted. Your lordship stayed the operation of
The
impugned
matter,
order.
the fact that this, we will take a call first of all on the interim orders to be passed.
Please, my lords.
Then we will take it up immediately.
My
Get
lords.
ready on the interim orders, we'll post it after 2 weeks.
My
Okay,
lords.
and also make a tabulated form of that,
We'll do that.
of the number of cases, list
We'll
after
do
2
that.
weeks.
Team will let them-
All right, we're going to pass the interim order, don't worry. Till then, don't take action.
My lords, I'll inform the department. Yes.
Much obliged, Lords. Much
Obliged.
obliged.
Grateful.
2 week ka date de dena.
Item 80.
Obliged.
Needs to be argued. This is those.
Malad, I appear for the state in this matter. Malad, I'm requesting for a passover. I'm being led by a senior counsel.
Tuesday.
Let it stay on the board at
Yeah,
its
it is
current
on.
position because then
Not
after
on board.
Yes.
With my
18,
lord's
19.
permission, may I mention item 26, my lord?
19.
My lord, I'm requesting a passover. Mr. Diwan is leading me.
All right. Now tell us, Who was mentioning this?
Item 20.
My lord, I was mentioning 19.
Just 1 second.
My lords, my lords, I'm mentioning item 26.
1 minute,
Mr.
1
Mehta
minute.
is online.
1 minute.
Mr. Nagra has mentioned item 20. Last order, in fact, said it will be a top 10 item. For the reason, my lord, we need interim
These
relief.
days are a big mess.
Only one was three concurrent findings of embezzlement and not a penny paid. That's right. Three concurrent findings.
That was stayed.
Not a penny paid by him. Three concurrent findings.
We have not stayed, no, Mr. Gandhi.
Exactly. And the executing court is adjourning every time because they say Supreme Court is pending. That's right. Very well. Lordship may say one line that the pendency shall not affect execution. Please say that. Please
We
say
have said
that.
We have said that.
My lords,
Kept it for final hearing, your lordship. Just say this word, pendency shall not affect execution.
We will do one thing. Looks like, listen to us, listen to us. I don't think it's an admission matter. It's a 34 and after 34, 37 also. So therefore one needs to pass an interim orders and hear the matter. So listen to us. We will, 37, it's a money matter.
Yeah.
It's a money matter. So therefore we will admit the case. We will not grant an interim order. We will post the matter in the regular hearing and we will expedite the hearing.
Expedite and one sentence that your lordship pendency will not affect. That's all. That's all. That's it. Okay. He knows that Tuesday will never reach. It's an international commercial arbitration. He doesn't want to be hurt, Balas.
Leave granted. Leave granted.
Can you do that?
Expedited. List in the month of March.
Obliged.
In the month of March, we make it clear that there is no interim order pending disposal of the civil appeal. Any amounts disbursed will be subject to the outcome of the civil appeal. We have to do that.
One point I just saying.
Don't argue.
There's nothing.
Don't argue the case. We are not here.
What is the argument? If we don't want to pay the money, three concurrent findings. Embezzlement. Embezzlement findings.
Execution will be subject to the civil appeal.
my lords, in item 26, Mr.
We are, every matter is going to come back because we are not adjourning the matters. This is a
March
continuing board. This is a continuing board. All your cases will be taken up and then.
My lords, I'm in item 26. My lords, in item 26, there are certain pleadings to be completed. So we're just requesting for certain time instead of each Tuesday bothering my lords. If at all some time can be given.
We have already said those who want adjournment can mention.
My lords, in item
Take it. We have already
26,
mentioned.
Yes.
You are not
Item
here. You
26.
want to repeat the point, please.
Yes,
4 weeks.
I apologize.
All cases where whoever wants adjournments, both of you, if they agree, you give. Otherwise, we will take up and dispose of matters. Only thing is, we all have to ask Mr. Dr. Singhvi, because of him, we are not taking.
No, well, because Mr. Chidambaram, your lordship as well as believing that now Mr. Chidambaram is still not finished. He still hasn't finished. I will finish today, Valas.
These 2 o'clock matters never get over because 2 o'clock are intended for poor people's matters. But then they occupy that position and
Today
then
your
they
lordship
won't
will
let
be
us
rid
do
of
any
that
other
matter.
work.
Today your lordship will be rid of that matter.
Fresh matters, we'll take it up at 2 o'clock. You took a Passover in that? A Passover will come next Tuesday.
Deeply obliged.
Sir, 26 May 6. Madam, 26 May 6 week.
Lord, one item 23.
54.
Item 23, I was to mention.
I'm not well. I just want to go to the doctor.
Sorry?
I'm not well. I just go to the doctor and come back in an hour.
Use the mic, we are not able.
He's not well, you want to go to the doctor.
I just want to go to the doctor.
Don't worry, don't worry. Don't worry, take care.
Sorry.
No, don't worry.
Well, item number 40. I was to
Item
mention.
54.
Item 23, I was to mention. 23.
Will come on Tuesday.
The Tuesday, I'm not
Okay, you want some other day, you take.
at the top. Well, item number 42 also. Next, Lord, coming Tuesday at the top.
Fresh matters, please.
Well, that's-
We'll do it, we'll take it on the top. Next.
If the same can be for item 20.
No, please, no more mentioning. Item 54. Second appeal में allowed the second 34, huh? Delay है. हाँ. Yes, Mister. What is this?
My lord, this is a matter
Yeah,
where the lady has been working for 30 years. He's a cancer survivor. She's the cancer survivor. And she went on leave for about 14, 15 days. And then when she resumed duties, she was refused employment. But however, since she was working in a private aided, she herself maintained an attendance, went to the school every day, and that has been reflected in her letter. May I just hand over a list of dates to your lordship?
Not necessary. This is totally beyond our control, this kind of a delay.
My lord,
Absolutely.
my lord. My lord, she has been working.
When is this? 2019 is the second appeal order.
Sorry, my lord.
The order is on which date?
Which order?
Order impugned, the original order is on which date?
My lord, the impugned order is dated 13/3/2024. The impugned order is 13/3/2024.
When the landlord will get possession, the decree of eviction was passed in the year 2007.
2007 order, Subhash.
Don't claim
Not
any
it.
title to the property.
My lord, this is,
2007 is the trial court decree.
my lord, this is something different. This is a service matter.
54.
Oh, I'm so sorry.
Where are you?
Oh, I'm so sorry, my lord.
Item 54.
Not 54.
Oh.
53. Sorry.
Yours is a fresh matter. No, fresh matters only we are taking. Just come on Tuesday. Come on Tuesday. Only fresh matters we are taking. Then wait 2 p.m. Wait. 54. Why you add in the supplementary list at 12 o'clock in the night and they don't
I'm sorry. I'm sorry.
No issues. 55, you don't know. Give a date in this.
For the petitioner. Once the trial court dismissed the suit for eviction, basis page 71, my lords, which is the admission made, my lords, that there are 9 directors who have not passed a resolution authorizing, my lords, the individual to institute the suit. Please see page 71. This admission on the part of DW or PW1.
Tell us few facts.
My lords, there was a rental agreement of 1993 between us in respect of 2 shops, my lords, on Commercial Street in Bangalore. That was renewed periodically. The last of those lease agreements was of 2005 for a period of 10 years. Now, after 2005, in 2008, a termination notice comes to be issued by the respondent, signed, my lords, by the Dharmkarta, saying he wants to terminate for breach. That breach is never established in the suit. Suit is filed by him, my lords, as the Dharmkarta without the trustees being arrayed as parties, my lords, in the teeth of the law laid down, my lords, by your lordships in 2005 Supreme Court, that all trustees must represent a trust. Now at page 71, basis an issue framed by the trial court regarding the authorization itself, please see the admission made, my lords, by PW1. 71, your lordships have.
technical only, but otherwise it's a reversing judgment.
My lords, the
objection is technical.
The High Court has not even gone into the merits. The trial court dismissed the suit on the basis, my lords, of authorization, which, quite frankly, my lords, on the basis of 71 admission, the suit has to go. He says that there are 9 members. It is correct that they have no authority to delegate. It is correct to say that no resolution was passed to issue the notice. So it's not known whether the entire trust indeed intended to terminate.
This is not governed by any statute, right? This tenancy. The only question was whether
106.
the notice under 106 was
Yes.
valid or not.
So that question would then, my lords, take us to the lease agreement. Lease agreement was for 10 years. He has not terminated, my lord, simpliciter. He has terminated for cause.
But there's
saying,
a finding that the termination of lease deed is valid.
my lords, there's just one paragraph. One paragraph without going into the fact that the allegation in the termination notice, the allegation in the termination notice was,
Take some time for vacating. How much time you want?
my lords, the termination was on the ground that I have sublet.
All
There
right.
is no material to show that I have sublet.
Not a case for us to interfere. Tell us how long will you?
I've been there now, my lords, 30 years. I'm running a shop.
That's what we say.
Please give me 2 years, my lords, in that.
Well, it's commercial. It's a temple property. 3 months, your lordship may give 31st of.
So I have a running concern. I have
Grant you 6 months.
Very well.
End of this year, if we can.
Because we are not inclined to interfere with the order passed by the High Court, we grant the petitioner 6 months time to vacate and hand over peaceful possession, subject to the filing of the usual undertaking.
Grateful.
Could it be till the end of the year, my lords? About 9 months or so. I have a running.
You're running there.
I have a retail
He's
shop,
subletting.
ground and.
Oh, yes, sublet.
No, there's no finding. Let my friend not say that.
We all know when it's commercial street.
What are you do? What are you selling?
It's a retail shop, I believe, garments.
Well, he's given it to some. 6 months is good enough. Let's.
Grateful.
Well, it's
Doesn't matter.
he hasn't also paid the rents.
He's
subject-
receiving rent.
Also paid the rent.
Subject to, subject
My
to clearing
friend
all areas.
say that off the cuff.
No, we have a
Subject to
statement.
Clearing of,
Well, let's.
1 minute, subject to clearing of all areas and payment of damages. How much is he paying?
Well, we asked for 35,000 rupees per month.
How much is he paying?
About 17,000 basis the agreed rent.
Only
It's not too sensible. So subject clearance all areas.
Please.
Very well.
I'm very deeply obliged.
6 months, Malak.
No. Till 31st of December. we get.
Grateful.
That will be minutes. The temple needs the property minutes. This is the only source of revenue.
Yeah,
It's a Ramula Sannidhi.
He is appealing to.
Let my learned friend also give and
That
take. Let my
temple-
learned friend also give in something.
Temple must always be, my lords, generous. Grateful to your lordship.
Grateful.
Lordship, I'm being led by Miss Liz Matthew. I'm requesting
Of course.
a Passover.
Counter it, but we are sending this.
I'm requesting a Passover. I'm being led by Miss Liz Matthew.
Friday. Next.
Lords, this also might have kindly be taken on Friday, Lords. I'm sorry, my file hasn't come. Extremely sorry, Lords. A very unusual request. Or a Passover, whatever. Or a Passover.
You realize what will happen? These matters come to us at around 11.
No, I understand.
12 o'clock. You understand, of course.
Your Lordship will kindly
Difficulty
pass it
in
on, Lords.
understanding.
I'm so sorry.
We're just telling you without you perhaps asking, they get listed, but they come to us at 12.
My Lord, it was listed yesterday and then it was adjourned for today.
And then most of the matters, which are coming about 8-9 matters which come at 12 o'clock,
My Lords, I'll argue from
most
my
of them get adjourned.
I understand. My Lords, my Lords, in fact, I'll argue from my mobile.
It's all
Lords.
fun. Okay, next.
On Friday, my Lords. Extremely sorry, Lords, once again.
It's not your, it's not.
In
not
fact,
your
nobody
fault.
was here, my Lords. And I
Not
was
your
to make a
fault.
mention in
It's a
another court.
systemic problem.
Yes.
Next.
So Mr. Vaibhav Gaggar is
The
appearing.
waiver of free deposit.
My lords,
Yes, Vaibhav.
my lords, a neat question of law only to the extent that under Rule 9(4) of the Security Interest Enforcement Rules, the auction purchaser has to deposit the entire amount within 3 months. 25% was deposited back in 2019. And in 2025, the balance 75% is permitted to be deposited. Clearly against the judgments of this Honorable Court as well as clearly against the rule. May I just show your lordships the rule over here?
How much is the pre-deposit?
My lords, the pre-deposit would, they're asking,
That you have to do the pre-deposit.
my lords,
The
the pre-deposit would be
DRC.
yes, pre-deposit would have been the issue of my liability and debt. Here, the issue that I'm canvassing is that I'm the corporate debtor, my lords. The issue I'm canvassing is that the auction purchaser could not have gotten the sales certificate unless he was following the mandate and depositing the entire amount within 3 months. He has been permitted to do that after a period of 5 years. And that I said, please allow me the waiver.
With all this, how much is the pre-deposit amount?
My lords, the pre-deposit amount would go into crores. I'm not in a position to do that pre-deposit, but I'm challenging it only with the auction purchase.
Theory. You are saying you don't have the money to give the pre-deposit. It's as simple as this.
No, that's right, my lords. Therefore, as far as the pre-deposit, my lords, is concerned, had it been the challenge to the default amount,
dismissed.
My lords, with the auction purchase, my lords, it's a separate issue.
Please.
Yeah, this part which is going on.
Yeah, this.
Huh?
No,
we are, 1 minute. We want to complete the part-heard matter. No, wait. Mr. Chidambaram just took time. That's why. He said that he is not well.
Okay.
So are we? Who is this advocate on record?
I'm for the petitioner.
No, Mr. Chidambaram's AOR. Who is it?
I'm assisting. I have been told he's not well and he's
No,
not.
that's okay. So then what do? Will he come back or will he's asking for accommodation?
He said he'll try to come back, but I leave it to my
No,
lord.
don't trouble him. You convey to him that we'll accommodate him today.
Right, my lord. So we'll have it next Tuesday then?
He didn't seem very well at all.
Then he was also very
Why did he take the trouble of coming all the way? He could have appeared online. No, tell him, convey it to him immediately.
I'll do that, my lord.
That we are, who is,
Next Tuesday?
we thought of completing it today.
Should not more than 4 hours. Mr. Chidambaram had already finished.
We won't
have to
take
rejoin.
20 minutes to half an hour, my lords.
We can start your lordship today.
Not well, madam.
No problem. You should have it Tuesday then at 2 p.m.
What do you say?
Next Tuesday.
We'll call him upon you.
Subject to my lord's next Tuesday, Mr.
At
Chidambaram
2
is
p.m.
taking email.
I know.
Sorry, sir.
Okay, Mr. Dr. Singhvi. Dr. Chidambaram is not well. So we'll accommodate him. Tuesday we'll take it up.
Very good.
So you are unemployed. Find out some brief.
I cannot have to argue mainly. Can it be the following 10th March?
Forget everything.
Very well.
We'll forget everything. And moreover, he has to complete it also.
No, he has hardly fully well. Anyway, next Tuesday. That's all. Work it out.
Please, my lords.
Is it okay?
My lords, I'll inform him.
To come next Tuesday?
He should be, my lords, we'll inform him.
Check up. You will check up and tell us.
Right now, in case there's change.
I'll just text him and ask him.
Okay, all right.
May it be the Lord. I appear for the petitioner here. Your lordships had my lord issued notice.
Where are you? You brought some written submissions?
Yes, my lord. Actually, I don't have a written. It's a very short issue.
Not take up matters.
Or
Don't care to write.
my lord, we filed a compilation as per your lordship's last order, but there's no written submission. Lord, no, very well. I understand.
I have just intended for half an hour.
My lord, if you then your lordship takes it up next.
10 minutes. Just start.
It should not take that long.
My lord, I'll just indicate the point. Yes, it's my lord. This is a case of
appointment, an arbitrator has been appointed under section 11, which we have challenged here on two grounds. Firstly, the arbitration agreement does not permit it. And secondly, assuming it does, my lord, it's a claim already decided under the same agreement by a previous arbitration award between the same parties. It is therefore a res judicata, although 34 etc. are pending, but the point is the award etc. has been passed, and whatever has been raised in the section 11 has been decided in the earlier award. That's my point. Point number 2. My first point, of course, is that the agreement does not survive anymore. The arbitral clause does not survive anymore. May I show that first? May I just give your lordships two dates, my lord? The joint venture agreement is 3rd February 2006. Which is, my lord, I'll just give 2 or 3 pages. No more.
The respondent in the section 11 application.
I am the respondent in the section 11.
Preliminary question, can't all these be questions raised before the arbitrator tribunal?
So I am answering that straight away, except that if there is an arbitration agreement or not is a question that the 11 court will decide, my lord.
No, not necessarily.
My lord, if I can show on the face of it, it doesn't apply.
Section 11, just see section 6.
Yeah, correct. I have seen your lordship's judgment also, the eye of the needle test, etc.
Eye of the needle is gone. Eye is closed.
No. Or very well gone. But even then, my lord, even then, if your lordship says so, I have to accept.
No, not that. What we are saying is that
yes,
even the existence of an arbitration agreement itself is an issue for the arbitral tribunal.
Unless, but my lord, it is not as if the 11 court has no jurisdiction to look at it at all. I hope I'm right there when I say that. And if I can demonstrate on the face of it, it does not survive, then my lord, the 11 court will not refer it to arbitration. When there's already an award between
Tell us how
when there is all, so my lord, I was just giving 2 dates for that purpose. One, the JVA between the parties is of 3rd February 2006. Now, in that, my lord.
Who are you in the JVA?
Sorry, my lord.
Who are you in the
so, my lord, there were 2 parties. I was the, my lord, I was the landowner. Other side is the developer. So, my land was developed by the other side. And there was a sharing of profits. 27% goes to me, 73% goes to him. That's how it was.
27 is to?
My lord, 27 as to 73 profits.
73, right?
Anyway, my lord, that was decided by the arbiter.
We are only seeing broad.
I know your lordships also. Now, my lord, may I just show to your lordships the arbitration clause, which your lordships will find at page number, my lord, 40.
Is it there in the EDU note?
It's my lord, it's not set out. It's at it's in the paper book itself.
Yeah, अगर हम ये द्रौपदी नहीं करते
Now, my lord, just before your lordships read that, I am giving one date, my lord, which is that between the parties, there is an inter-parties award dated 12th February 2019. Your lordships may note that. Just note it. I'll take you to 1 or 2 pages of that. 12th February 19. Now, our final arbitration award between us. There was an earlier arbitration in the same agreement.
Wait, 2006 agreement gave rise to disputes. Which culminated in
this award between the parties. Now they want a second arbitration. Now, my lord, would your lordship just have a look at the clause?
Complete the facts.
Yes. No. So now I'm showing you the clause.
Then what happened? When did the other issues arise now, which led to the second?
Now what has happened is that according to me, and which I'm going to show to your lordships, firstly, the clause of the arbitration clause in this case says that this clause will apply only during the subsistence of this agreement. The arbitral award in the previous case between us has given a date on which this agreement stands terminated. Therefore, my lord, today this arbitration clause does not exist is my point number 1. Therefore, I wanted your lordships to kindly read the clause, which is at page 40.
Arbitration agreement has got nothing to do with contract.
My lord, of course, it is otherwise an independent agreement. Agreed. No question. But, my lord, here it is linked with it. Now, please see, my lord, page 40, para 30, clause 34. My lord, kindly see. All disputes and differences whatsoever arising out of or touching these presents or the construction or application thereof or any clause or thing contained including the performance of respective obligations of each of the parties hereto during the subsistence of this agreement shall be referred by parties etc. to arbitration. Now, my lord, please see the finding of the first tribunal on this issue, which is, my lord, at page, I am just showing one page, my lord. My lord, kindly come to the finding on issue number 2, which is, my lord, at page 138 onwards. In fact, my lord, let me show the conclusion. Forget, my lord, I'll just cut it even further short. Please come to 184. Lord, let me now, Lord, since your lordships are saying I have to be broad, I'll be as broad as possible. Yes.
180?
Lord, 184. Now, these are the final reliefs that the arbitral tribunal has given, my lord. Please read B, my lord, with me. It is, however, declared that joint venture and supplementary agreement stand terminated as on 30th March 2010. Pause here. Now, the rest of the clause I'll read later.
As on means?
My
What is
lord,
the date of that agreement?
that is 2006. According to us, it was terminated prior, but the tribunal has now said, finding of fact, finally binding between us, subject of course to 34, etc., that this agreement is terminated. Now, normally your lordships are absolutely right when you say that the agreement is independent of the arbitration clause, but here it has been linked in the clause itself, namely that during the subsistence of the agreement, whatever disputes arise will go to arbitration. Here, in an earlier arbitration between the parties, that agreement is said to have been terminated, held to have been terminated on 30th March 2010.
Then what happened?
So, my lord, this is my point number 1.
Then what happened?
So,
How did
now the award comes, my lord. We have both filed 34. That is the position there. He's also filed. He has in fact filed an execution of the award also. But we are at that stage. I am therefore saying today to your lordship that there is no...
How Section 11 arose? Tell us that fact.
Section 11, now I'll come to that. Your lordships have asked exactly the question I was coming to. My lord, in the Section 11, now let me show it from...
Subsistence of the execution petition.
Yes.
That he has again gone back for filing.
He has filed, and yes, and he has asked for 3 things, which, my lord, in my respectful submission are covered by the award, which I'm going to show to your lordship. But those 3 aspects that he wants now decided by the tribunal afresh is at page 3 of the impugned order. Please see it from the impugned order, my lord. I can show it from the application also, but I'll show it.
What does it want?
Yes, ma'am. Now, please see, my lord, para 3 at page 3. On the declaration of award, some other disputes arose between the parties. This time it is in relation to outstanding municipal dues payable to Pune Municipal Corporation of so-and-so, income tax liability of so-and-so being minimum alternate tax, payable by joint venture on account of default attributed to the respondent, and a claim of loss to the tune of 224 crores, etc., etc. Now, each of these 3 is covered by the previous award. I'm going
Covered by the award itself.
Covered by, that's what I'm saying, bro.
That is one point. Another point is that these disputes could also have arisen at the time when he filed a claim statement.
Claim statement in the previous matter. Correct, no? It could have. But what I'm saying is that now if I take your lordships to the section 11. Now, my lord, so now, then.
Read further.
No, now, by this order, the High Court has appointed the arbitrator. So, I am saying now.
What is his justification for not raising these claims at the earlier time?
There is no, in fact, I'm saying there is no justification at all, is my argument before your lordships.
What does the High Court say?
No, so the High Court said, we said.
Read further, please.
Yes, I'll read. For this, may I read below the second part of page 3? For this purpose, on 27/11/22, I'm going to show this communication. Applicant addressed a communication to the respondent claiming the aforesaid amounts, also seeking direction to provide KYC document to the bank so as to activate the bank account to make the necessary payments. It was communicated that in case there is a failure to respond, arbitrator shall be appointed for resolving the dispute. Since there was no response at the end of the respondent, applicant has moved the present application seeking appointment of the arbitrator in the wake of clause 34, same clause which I read, of the joint venture agreement in respect of development of property by taking benefit of stipulation.
Second part of paragraph, page 4.
Page 4, para 5. Is your lordships on the last paragraph?
The
applicant state his claim. This is in another suit, my lord. Applicant state his claim that the attachment is bad in law. It is not in the hands of the competent authority. Apart from this, a stand is taken that there is no demand as regards the said areas and the auction of the flats is illegal since it is in excess of the amount which may be due and payable to the that's between the corporation. The corporation had attached some flats because taxes were not paid. So that is the suit. But I'm leave the suit aside for a minute. I'm saying this has been decided by the arbitration. May I take your lordship now to the section 11 for a minute?
He is saying in paragraph 6
yes,
that in the interregnum, since the liability of the income tax. So what do you mean by interregnum?
Well, Lord, I'll show it from the section 11. It is not in the interregnum. Because even if it is in the interregnum, it is covered by the previous award, my lord. This arises out of the sale of 140 unsold flats. 140.
When did that arise?
Unsold flats are dealt with in the award itself.
We are asking about this so-called interregnum of income tax liability.
The income tax liability may have existed at any time, but it arises out of the 140 flats which are unsold, which have to be sold and divided amongst us, which has been dealt with by the previous award. So,
Even this one, is it?
yes, even income tax, etc., will all be subject to once that award is executed. Obviously, income tax will be paid. Obviously, property tax will be paid.
This liability has not arisen, income tax liability, according to you, has not arisen after 12th of February 2019.
According to me, no. But assuming for a second, even if it has, it is covered by the award. Even if it is prior to that period.
How can it be covered?
I'll tell your lordships how. Now, may I just show the section 11 for a minute? Just have a look at one section 11. Please come to page 235.
No, section 11 before.
Section 11, I'm sure. No, sorry. Section 11 petition, sorry. 235. It starts at I'm going to give an opportunity. It starts at 229. I was at 235. But I just want to say one thing before I read that. The whole case here is this. 2773 has been divided by the tribunal, arbitral tribunal in the previous award. I am saying I'm willing to pay 27% of the income tax and property tax also. He now says I have to pay the full amount. That's why he's created this dispute. I am saying I'm fully willing to go by the award. I'll pay 27% of the income tax. I'll pay 27% of the property tax. But you have to, under the award, pay 73%. It can't be 100% on me and go for a fresh arbitration on that issue.
Just check with him.
Can I just show one page at 235? I just want to show and then I'll finish in 2 minutes. 235, para 12. This is now part of the section 11.
When did you say about this new liability?
I'm in the section in the notice that was preceded, which preceded the section 11.
Date?
I'll give the date.
27/5/2021.
Yeah, correct.
27/5?
27/5/22.
22. 27/5/22, Milo.
3/2006 and award is 12/19.
Correct. I just wanted to read 2 paras of that section 11. Just, in fact, 1.5 paras. My lord, please see para 12 at page 2.
The agreement. February.
I wanted to show my lord 235 para 12. This is how the earlier award is mentioned in the section 11. And then what he wants here, I'll just come to that. Arbitral tribunal, if your lordships have para 12. Arbitral tribunal passed an award on 12 February 2019, inter alia held. Respondent have brought the larger property into a joint venture as a share in joint venture with certain reservations, etc. By the award, arbitral tribunal held that joint venture is entitled to residuary TDR, DCR other than playground and sale proceeds would be shared in the ratio of 73 and 27 between applicant and respondent. It is clear from the award that 140, now this is the issue, 140 flats of the larger project are completed, but they remained unsold and the properties of the joint venture. By the award, arbitral tribunal permitted joint venture to sell the balance flat and realize the proceeds and share the same in the ratio of 73 and 27 between the applicant and the respondent. Now, my lord, para 16, just one line para. In the meantime, the various notices have been received from PMC demanding areas of municipal taxes with respect to the unsold flats. Unsold, 140 unsold flat, my lord. Now, my lord, please see what he says, what he wants now, which is at page number 244.
It's the quantum, Mr. Bhatnagar.
But the award takes...
Don't confuse with them. You have made a good point. I mean, we're not
my lord, please permit me to complete the point. Your lordship may be convinced. I'm just putting it just one further thing. Now, my lord, 244, and I'll just show the award after this, and then I have nothing further to say. My lord, 244, para 28. Now, this is what he wants. This is the letter of 27th May 22, which is repeating in the section 11. In the premises, applicant through his advocate's letter dated 27th May 22 invoked the arbitration agreement contained in clause 34 of the first joint venture agreement, requested the respondent to provide KYC documents of the bank to activate the bank account. I have no objection to this. Pay an amount of 10 crores, etc., being areas of outstanding municipal taxes payable to PMC. I have no objection to this up to the 27% limit set by the award itself. Then, my lord, see, income tax liability of 28 crores being the minimum alternative tax. Again, I have no, my lord, objection to 27%. D, paid 220 crores. This award of the previous award has said that no damages are to be paid to him, my lord. How can he again re-agitate damages in a fresh arbitration when the previous award has given him no damages, no specific performance, my lord? I ask myself. Now, let me show that from the award itself.
Once you say the first two, you are willing to pay.
Yes, up to 27% as per the award.
Part you are not willing to pay. That's an issue which the arbitrator will decide. So the question you are arguing is not about maintainability of the arbitration. You are arguing about what quantum is permissible, what not permissible. Don't confuse these two.
No, I'm not confusing.
But so far, don't even refer to these amounts. When you raise a first
He has
ground,
raised it. He's saying yes. Sorry.
raise the first ground. Why should you be saying what you are entitled to?
No, I'm not saying what I'm now, my lord. Let me show to your lordship.
Confine yourself to first point.
Correct. My first point is there's.
Why is it barred? You tell a formulate.
I'll just formulate it in 2 points. It is barred. Firstly, as I said, because as per the existing subsisting arbitration award, the agreement does not exist.
This is a liability which arose subsequently, and that liability is relatable to the finding in the arbitral award.
That liability is covered fully by the arbitration award, is what I'm saying. That's why I wanted your lordship to look at.
It be fully covered because
I'll show your lordship.
Because your award came in 2019 and liability arose in 2022.
No, that is because the general direction of the award covers it. That's what I'm trying to say. Obviously, there will be no specific direction.
So then how will he go to execute the subsequent liability without a decree in his hand?
He will execute it on the basis of the directions of the first award. Let me show that to your lordship straight away. Please come back to 184, my lord. That's what I'm trying to say. Please look at B and C again with me. B, my lord, it is, however, declared that joint venture and supplementary agreement stand terminated. This I have already shown. Joint venture, however, is entitled to sell the balance flats and realize the proceeds. The income to be shared in the proportion of 73-27 between claimant and respondent respectively. Then see, on the flats being sold, money is realized and accounts made up, the joint venture will be dissolved. So obviously when the flats are sold, etc., tax liabilities have to be paid, my lord. It's part of this B and C. My lord, I ask myself, how is it ever possible, my lord, that tax will not be paid under B and C? Damages, this award says no damage. Always.
Get an essence, you come back.
Well, it's
Come straight to the point.
straight to the point. First award was dealing with the percentage sharing ratio.
It's not relevant.
Award says that the joint venture is to be dissolved once all flats are sold and corresponding rights and obligations are fixed. And that is in terms of clause 31 of the agreement itself. Till the time the joint venture is not dissolved, joint venture is going to exist between two of us, which has got three features which are subsequent to this. 140 flats which are to be sold, and we both need to cooperate to sell because we are the shareholders in the joint venture. Two, they had to give, because they are a landowner, they have to give me certain information based on which I will claim income tax exemption under 80IB, which grants the 100% exemption. Which, unless he is going to cooperate, the entire liability is going to be joint venture. Third, he says joint venture, which is admittedly joint venture is existing, not dissolved. Subsequent liabilities on these 140 flats, he says because 7327 has been done, therefore everything functions official. I ask myself a question. Income tax liability is not on individuals.
Our question to you is this. A contractual clause.
Yes.
Arbitration clause stands on a different footing from the contract.
Absolutely, that's yes.
How long will it subsist?
Till the time the joint venture is not dissolved, and the first arbitral tribunal was conscious of this, page 185 clause C. This is the same clause in section 31 of the joint venture agreement. I'll show. That's why when in the first award, the arbitrators knew that 140 flats not sold, multiple assessments years are pending in which the joint venture be under, there's going to be liabilities between two of them. Section 31 clearly, and they have only incorporated section 31 of my joint venture agreement. The so far arbitration clause is a standalone separate clause, not a problem. The termination of agreement is not going to take a...
When did your cause of action arise?
But the cause of action...
When did the cause of action for invoking the section 11 arise?
The section 20, after the award, yes, 2021 is the, I'll give the exact date.
When
I'll
did
give the
the
date.
cause of action for filing of section 11 arise?
September 2019, Malas. Because by that time, two things happened.
September 29 is the date of the award.
February 29 is the award.
What happens in September 19?
Two things, grateful. By that time, the first assessment was made, income tax assessment was made, and 80IB was denied, which means the entire project which was planned on the basis of that this will be tax exempt is because of their fault. The liability of 28 crores in 1 year came, and subsequently will continue to go against that. That's one.
September 2019 is an assessment order.
Yes, of that year 19 onwards, and therefore continuous. Second is
September 2019, which you say is the cause of action, is the income tax assessment order.
yes, 28 crores. I'll show the and second is the BMC. Absolutely.
So that's the
Yes, Manoj, yes.
So subsequently, similar
liabilities are there.
So those assessments, according to you, have to be shared.
Absolutely. And how do we share? It's not as simple, my learned.
When did you go to section 11?
Section 11, the I have filed is because notice is 27th May 2022, Malas.
So they are subsequent.
Yes, all these are subsequent, and we have exchanged multiple in between. So all this communication has been, they have filed a suit against BMC. That is all subsequent action, and only clause of the agreement.
It's a principle akin to order to rule 2.
Yes.
It will not apply in this case, perhaps because of the reason that the award contemplates subsequent liabilities and keeps it open-ended. And subsequent liabilities arose, and as they arose, we invoke that.
Yes, that's and page 39, only one clause of the agreement.
Just give me 1 minute. Just give me a minute, and then whatever, Lordship, please. Firstly, the cause of action para in the section 11 does not mention anything about the subsequent liabilities. It mentioned by suit. Now, number 2, look at the consequence of what is being said before your Lordship. If Milord, we don't go by the 2 paras in the award, the 2 conclusions in the award, in which I say it is covered. Today he's saying as per a 22 notice, this is the income tax, so he has to go to arbitration. Tomorrow he will say as per a 26 notice, I've got a further tax liability, I'll go for a 3rd arbitration. Then there'll be a 4th arbitration. Milord, it cannot be, Milord, with great respect.
Not in perpetuity. Yes, you are right.
Can't be,
That's the question we asked him.
Exactly. So therefore it has to be.
The question we asked him.
I know, Milord,
but the doubts that you have in your mind have not arisen here. For the reason that when they invoke the section 11, in September 22.
Yes, my lord.
The cause of action for which arose in September 19.
No, that's not what they've said. I wanted to show that to your lordship.
When did it
Please see 263.
When did it arise?
I'll read it then if your
So
lordship.
therefore, to the extent that any claim is raised, I
My
think
lord,
it's based on your what?
He says the cause of action arose not because of tax notices.
You have a good case here.
He says the cause of action arose because the corporation auctioned the property. My lord, it's a totally different. That, my lord, let him at least mention that because of tax liability cause of action arose. I can then understand it. But my lord, otherwise then there will be at every stage there will be some notice and there will be a fresh.
Mr. Especially petition is against the judgment and order. Disposing of an application under section 11 of the Arbitration and Conciliation Act, constituting an arbitral tribunal for resolution of disputes between the parties. Full stop. The order. This is based on the basis of an agreement dated 3/2/26/87. Mr. Bhatnagar, learned senior counsel, has raised some very important questions about which have important questions relating to continuation, existence and continuation of an arbitration agreement. Of the arbitration agreement, particularly when it has culminated in an award award dated 12/2/2019, and its so-called further continuation till 2022. He also submits that all issues arising for consideration have conclusively been determined in the arbitral award, and that the arbitral, he would further submit that an arbitral award, the arbitration agreement, cannot be expected to continue in perpetuity. While we are not inclined to interfere with the order passed by the High Court constituting the arbitral tribunal, we leave all the questions relating to maintainability, maintainability, and what? Existence, relating to existence of the arbitration agreement, existence and subsistence of an arbitration agreement, including the question of limitation to be raised and contested before the arbitral tribunal. Needless to say that the respondent will be heard before final orders on the preliminary issues made by the arbitral tribunal. Finally, okay.
If your lordship will also consider saying that maintainability of the claims also.
Everything.
That may come.
Yes, just to clarify, my lords have said that the preliminary issue order, that's determining on the final order, whatever the remedy.
No other remedy.
Yeah, that's what I'm saying.
If he wants, he can. Nobody does, but actually arbitration can make awards in part.
My lord's words coming from here are very powerful. So that's what I'm saying. Just please record my submission on this part. That's all I'm saying.
No, he'll be heard before it is passed. So that's, I think, good.
Remove the preliminary.
I'm obliged.
Next. With these directions.
My lord, let it be preliminary because this is a preliminary.
There can't be honestly that I can.
Please not a joint argument on that. We've said it. In fact, even assuming preliminary, there is no remedy against that order.
There's no, you have to wait till the 34.
34 order.
That's right.
Yes.
So why not?
Obliged.
Okay.
You can always make multiple. You can make an award of preliminary.
Deeply obliged.
Grateful.
They don't do it. That's the problem. They should.
With my lord's permission.
Item next.
Item 52, my lords, we've been led by Mr. Chidambaram. I've informed him, and I've informed the opposite side as well, Dr. Singh and Mr. Chidambaram. They'll both be there on Tuesday, 2 p.m. next Tuesday, my lords. 24th. Please, deeply obliged.
Item 51.
I appear in 51.2.
Lead 51.
Yes. Yes, sir.
Please, my lord, not just small submissions. I'll just tender for us. Brief submission. Yeah. Please, my lord. Petitioners, my lord, 5 of them before my lord, they were elected as directors, my lord. Now, taking into consideration the peculiar bylaws of this particular society, my lord, that is Amravati District Central Cooperative Bank, which is a district level cooperative
They
bank.
are elected as directors of Cooperative Society.
Of the cooperative bank, sent as representatives from 14 different talukas, my lord. That is because based on the principle of cooperative federalism, they get elected from those talukas, and those talukas, they send them as representatives to the district level bank. That is the Amravati District Central Cooperative Bank, my lord.
Amravati District Central, that's the bank, no?
Yes, Amravati District Central Cooperative Bank is the bank, my lord. Respond number 17.
District Central Cooperative.
District Central Cooperative Bank.
5 of them.
5 of them, my lord. Before my
Directors.
Elected as directors, my lord.
Then what happened?
My lord, 2021 they were elected as directors. Now 2024, my lord, 12 to 2024, the respondents 1 to 14.
No confidence.
They initiated no confidence motion against them when they were elected from different constituencies, and they were not the electors so far as these directors are in question are concerned.
The facts.
Yes, my lord.
Don't argue.
Yes, my lord. So I'm so sorry. They submitted requisition. Respond number 15, the Divisional Joint Registrar on 20th February 2024 rejected the requisition, my lord, for no confidence on the ground that they are not competent to move a no confidence motion against other members, and that only the electoral college which elected them could initiate such action. My lord, that order of the Divisional Joint Registrar was challenged in writ petition number 1437 of 2024, my lords. Now, despite there being an alternate remedy under section 154 of the Maharashtra Cooperative Societies Act for revision, my lords. Now, that writ petition was allowed by the Honorable High Court, interpreting section 73(1)(d), the way it was done.
Saying that it's maintainable.
It's maintainable, and they could have
Only
initiated.
question, after the High Court, you got a stay here?
Yes, we have got a stay, but we approached your lordships after the High Court order, and there is a stay. And as a result of the stay, we are still continuing as directors, 5 of us over here. We are still continuing. But the interpretation the High Court has given, specifically while interpreting 73(1)(d).
Well, members can
other board of directors, co-directors, they cannot move a no confidence
what's
motion.
the clause relevant?
Yes. 73(1)(d) is set out, page 11. But the facts that are set out and the discussion is in respect of the connected writ petition. My facts peculiar to my case and my bylaws specifically are not taken note of, because 73(1)(d) specifically says the one who elects can move yes.
A president, vice president,
page 11,
chairman, secretary, treasurer, or any other officer.
Page 11, my lord, page 11 of the impugned order.
File there, na? Oh, this is a difference. 1D.
Please, my lord, 228, page 11. Yes, my lord. Officer means a person elected or appointed by a society to any office of such society according to its bylaws. According to its bylaws is going to be crucial, my lord. According to its bylaws, because I have given a chart.
Any elected or appointed?
Includes such as chairman, vice chairman, president, vice president, managing director, manager, secretary, treasurer, any member of the committee.
And includes office where.
Please. According to the bylaws, your lordships may mark.
Point you are emphasizing in the definition?
According to the bylaws, elected according to the bylaws, because I have given a chart along with the written submissions which shows the different constituencies in terms of which they get elected specifically. It's not a common constituency as such, and therefore 14 different.
An officer under 220 means
Yes.
that elected according to bylaws.
Yes, yes, elected according to the bylaws.
An officer who
Yes.
holds office by virtue, then come to 73 1D.
Yeah, 1D. Yes, yes, Manoj. I'm grateful. Motion of no. An officer who holds office by virtue of his election to that office shall cease to be such officer if a motion of no confidence is passed at a meeting of the committee by 2/3 majority of the total number of committee members who are entitled to vote at the election of such officer, and his office shall thereupon be deemed to be vacant. Who are entitled to vote at the election of such an officer is again going to be
Majority of the total number of committee members.
Yes, sir. Who are entitled to vote at the election of such officer who is sought to be removed by of no confidence. And then subsection 2, my lord, the requisition for such special meeting shall be signed by no less than 1/3 of the total number of members of the committee who are entitled to elect the officer of the committee and shall be delivered to the registrar. My lord, again, it's reiterated, the ones who actually elect, who are part of the electorate, who are part of the constituency, alone can initiate proceedings for removing.
So what's your argument?
Yes, my lord. So therefore, these, my lord, with the submissions, I have annexed this chart, my lord.
Members who move the requisition.
Yes, yes, the 14 of them, they are from different.
They have to be elected members.
They are elected members, my lord, but they are from different constituencies, not from my constituency as such.
What should they be?
May I just point out from the chart? My lord, yes. This who are elected is what I read, my lord. Again, I'll read, my lord. 73 1D. Officer who holds office by virtue of his election to that office shall cease to be such officer if a motion of no confidence is passed at a meeting of the committee by 2/3 majority of the total number of committee members who are entitled to vote at the election of such officer.
First of all, what's a committee?
Committee is the managing committee of the directors, my lord, comprising of 21 directors.
Directors or governing body or other director of cooperative society. All of you belong to the same cooperative society, right?
But we are representatives of the primary agricultural credit society, my lord. We have come over there as representatives to this particular body. And again, subsection 2, lordships may have for a moment. Subsection 2.
Are we not concerned about the cooperative society?
It's a cooperative society. It's a district level cooperative society, my lord, where representatives are sent, 14 of the representatives from the taluka level.
So those 14 representatives.
Yes.
Are within the definition of the committee.
Yes.
Means constitutional manager, board of the director, or other directing body.
They may be referred to as member. They may be referred to as member of the managing committee, my lords.
It's the committee of management or board of directors. Board of directors.
Yes.
So therefore,
they are members.
You didn't show us the board of directors. So these elected members, do they not form part of?
They form part of the committee
or governing body.
They are part of the managing committee, board of directors, my lord. They are part of that. But the constituency through which they are elected, therefore this chart is going to be crucial, my lord. This chart I annexed with the written submissions. Now these 14 members, all of them, even petitioners as well as respondents, we got elected from these constituencies.
We are the board of directors.
Yes,
14 members are the directors.
Yes. Total 21. 14 elected.
These 14 are those who have moved the application, is it?
Yeah, yes, madam. 14 elected from different talukas as per clause A, 8A.
Then 5 directors.
Yes. Now all of them they are from
category.
Yes. Then there are 5 directors elected from reserve category and 2 directors are co-opted, my lords. In all, total 21 directors on the managing body, managing committee. Now the issue is, my lord, these bylaws or the peculiarity of so far as this.
You got elected from where?
My lords, I got elected from.
You are the elected from the reserved category one or the 2 directors?
No, my lord. Varud, my lords.
The last.
I have mentioned in the last column on the right side, my lord.
Then why are you drawing a distinction between the directors?
I beg my lord pardon.
Okay, complete your argument.
Yes, my lord. So we are elected and that is the limit, and therefore divisional joint registrar specifically went on to hold that since the ones who move that application or no confidence motion requisition, they are elected from different constituencies and therefore they have no right or locus whatsoever to issue a no confidence motion, And the ones who have elected us, that is the taluka level electorate in question, only they could have removed us by interpreting section 76 1D, 73 1D specifically. And Mulad, may I make myself?
Bringing all these.
Mulad, specifically in view of this particular provision, Mulad, 73 1D, I'll again read, Mulad, 73 1D.
An officer
Who holds office by virtue of his election to that office shall cease to be such officer if a motion of no confidence is passed at a meeting of the committee by two-third majority of the total number of committee members who are elected to vote at the election of such officer. Lord, this is going to be crucial. Who are elected, who are entitled to vote at the election of such officer and his office.
They are talking about if a motion of no confidence passed at the meeting of the committee, meeting of a committee, mark that, meeting of a committee
Please, my lord.
of two-thirds majority of the total members of the committee members.
Yes, my lord.
Who are entitled to vote
yes.
at the election of such an officer in
yes.
his office.
Yes.
And his office shall thereupon deemed to be vacant. What is the distinction you are bringing about?
Yes, my lord.
Total number of committee members.
Yes,
Committee means you are talking about board of directors.
Board of directors. Board of directors. My lords, board of directors for removing these directors in question who are part of board of directors. The other co-directors, they cannot move a notice of no confidence is what I am submitting. It can only
Tell
be
us
moved.
one thing.
Yes.
The 14 directors as well as the 5 directors or the 2 directors are all them not members of the committee of members?
They are committee of the members of the board, my lords, but they are not the ones who elected the ones who are sought to be removed. That is the point I am trying to make, my lord, and that is what is reiterated twice.
What is the basis for your argument?
Yes, my lord, I'll just point at 73 1D lords have for a moment. Who are entitled to vote at the election of such office.
What is the hierarchy? Yes. How do you get elected?
My lords, we get elected from these talukas, my lord. The talukas.
Okay, tell us at the bottom is the taluka.
Taluka, yes, my lord.
Show us the structure. Tell us the structure.
Talukas.
So from out of a taluka, what happens?
14 of them, they are elected from these talukas shown in the chart. These are the talukas that are specifically mentioned over there.
So 1, 2, 3, 4, 5, these talukas.
Yes, yes.
So from out of talukas, each one of you
get elected to the managing board.
Each taluka is a unit of election, is it?
Unit of election.
One members get elected from one taluka.
From one as a representative of that particular taluka in question, and it's a separate electorate.
And so many of those taluka representatives together elect whom?
They form the part of that managing committee, my lords, of the Amravati District Central Cooperative Bank, which is the district level bank.
They elect the president.
And then they in turn elect.
All districts will elect what?
No, no. Then it will be a state level body. That's a separate issue again, because state level bank will be chosen. May I just point out one?
Now, at least this one. I don't know. One means one member gets elected.
One from one representative from each taluka gets elected, and they form part of that managing committee of the state level body. Now, this is what is provided in the bylaws specifically. Lordship may have the bylaws in question. Additional volume.
Page 33.
Page 11.
Page 33.
You are all representatives, is it?
Please, my lords. We are representatives of these talukas who are sent to represent these talukas at the district level bank, that is the Amravati District Central Cooperative Bank, respondent number 17 before, my lords. Now the point is, my lords, since it's a separate electorate and these are separate talukas, some other director elected from some other taluka who has not elected me.
But you lose your identity the moment you get elected.
Please, my lord.
All of you are going, it's like saying a member of legislature.
Please, my lord.
From a member of parliament.
Please, my lord.
Gets elected.
Yes, but
from some Amravati constituency.
Please, my lord.
But when he's sitting in the parliament,
please, my lord,
he's sitting along with persons who would have been selected somewhere around from Assam MP. All those lose their identity from where they came. If they have to move a no confidence motion,
please, my lord,
you can't say that.
My lord, my only point is no confidence motion can only be moved by those electorates who elect me. That right of democratic recall can only be by those electors. It's not a case of removal or disqualification.
Removing you from your primary membership. They are removing you from
as a director,
board of directors.
As a director.
You don't need primary members won't remove you.
No, but my lord, my case is specifically that only primary members who have elected, once who elect can only remove, is the general principle. My lord, here.
They are not removing you primary membership, they are removing you from board of directors.
From board of directors, which they could not have done is what my specific case is, my lord. Because may I just
Your
point
case.
That is my specific case because,
What
and
is
that is
the
what.
High Court say, just see?
Yes, my High Court. But may I take lordship to the order of the divisional registrar, my lord? Page 17.
Jain, just to try and understand, is that the case that he set
Yes.
up? Just to be fair to him?
No, he's in the second.
That's the case. The case that he says is that it is not the committee that can vote by the particular majority in 73(1)(d), but it has to be the general membership of the society.
Who elect me?
Which is directly in the teeth of 73(1)(d). The only two questions.
Suppose if the resolution is passed,
Please, man.
you will cease to be what?
Only a member of the committee.
Only member, but I cease to be a director. That is a member of the
You
committee.
cease to be a director.
Director, yes. That is a no confidence.
That is the office he is holding. I'm in a different case. I'm in
But he will not lose
he's
the
a-
member of it.
No, he will certainly not.
That's the point.
I'll just say there are two issues are there. The only
You
two
will only,
issues.
you will only lose your appointment
As
a
director.
director,
Please, my lord.
but you will not lose your membership as a director.
Yes, my lord, I lose.
Para 11 at page 20.
I lose that director. my lord.
Para 11 of the High Court judgment
May I just point out, my lord,
is
the order of
Well,
the
there are just-
divisional right.
I'll just clarify. There are just two issues, my lord. Is the person an officer? If he's an officer, then under 73(1)(d), what is the process for a no confidence motion? The High Court says he is an officer. If he is an officer, the members of the committee who are entitled to vote at general elections. Well, there are some nominated members who may not have a vote.
That's right.
So as opposed to those, all the others, 2/3, if they form that majority, remove him as an officer, not as a general member. That is what para 11 directly. There are two different societies. I'm in 51.2, but this is the short question. Right? Is he an officer? And under 73(1)(d), what is the process for no confidence?
I'm not able to understand. Maybe it's
That's two matters. my lord.
There are three items, Millard. Two different societies. I appear in 51.2 for a different society. But if your lordship sees, Millard, para 9 to 11 is really the reasoning that if you look at the scheme of the Act, Section 71(d)
Lord, here again, I must
and
say-
Rule 57, the members of the committee can move a requisition. And those members of the committee who are otherwise entitled.
May I just point out one? My lord, my specific contentions and my bylaws are not taken into consideration. What is taken note of by the High Court? Only may I just try and persuade my lord, are the facts and bylaws of my friends writ petition, my lord. My specific bylaws, and that is my specific case, because every society stands classified in terms of the bylaws in question, and therefore my bylaws specifically require that all the talukas are to be represented. Now, difficulty, what will happen, my lord, here? If co-directors start removing for political reasons, the taluka in question lose its representation, and that is against the principle of cooperative federalism, is what I wish to submit, and that is what is specifically, may that try and convince my lord, and that is what goes against 73(1)(d), because not once but twice it is so reiterated that only ones who elect will have a right to remove by of no confidence, because this is not, my lord, about disqualification or removal. This is a proceeding initiated in terms of no confidence.
in the light of which we cannot see any reason to declare any violation. And so why the reputation is concerned? Where is the question of law formulated by the High Court?
No question formulated, no less. And only para 20 minutes, short para, my case is only recorded that there is a connected writ petition. No independent consideration so far as my case is concerned.
Officer, the word is very clear. Your
Well, it's-
taluka members
taluka members, once they get elected, may I just point out, once they get elected to the managing committee, they are going to be the officers, and officer or maybe directors. But only thing is my submission, this is a no confidence motion. Your lordship will take
51.2. What? What, Shivaji? Tell us honestly, tell us. What's the problem?
Well, this is a totally with respect to the High Court, this is not possible. The interpretation what the High Court has placed. Like, we
don't want a comment, we want an argument. Tell us what.
These are
You keep appearing in this cooperative. You tell us.
Yes,
what's the problem?
presently I am a chairman of a cooperative society.
So therefore, your members have moved a chair, no confidence and removed. What's wrong about it?
This is only this provision 73(1)(d) is meant only for a no confidence motion against the office bearers of a cooperative society. Not like we are 5 in number.
It is an officer only.
We are elected by the general body. All 8,000 members elect us. If you read the provision, it is clear.
It's not a general.
73(1)(d).
Page 11, Milord. Section.
Page 11. May I read 73(1)(d)? I will explain. This like one set of directors, majority. They are in majority.
Explain the structure.
Yes, I'll explain. There are various constituencies. While they elect for a 5-year period, they are elected. They elect the managing committee. All the members. They are all the general body of every cooperative society. Here there are about 8,000 members. They elect directors. There's members of the managing.
Not a direct election.
Managing committee. Managing committee. They call it
the primary members. 8,000 members don't elect the directors.
They elect the members of the managing committee. They, on behalf of members, they supervise the conduct of the society for the period of 5 years. They are in charge of the affairs of the society. And after this election is over, all these the elected members, in my case there are about 21. We are in minority, only 5 in numbers. When they were taking the decisions, not in the interest of society, when we oppose, what these majority directors did, they moved the registrar for no confidence motion. That this cannot be done. It's the provision may I place your lordship like any
the primary members, what is the first tier of election? What is the indirect election? Tell us from the very beginning. You've been doing this matter from ages.
Election happens every 5 years. Primary members.
Primary members means that in a cooperative society, members of the cooperative, first of all, elect whom?
Managing committee.
Directly managing committee.
Agriculture cooperative society is the basic society, taluka level society.
There are societies, members, individual members are also there. Societies and individual members are
just read one paragraph.
Let me place the provision, it will be clear to my mind. Let me place the provision.
They have to be elected as representatives, and that's why they are members of the managing committee. Members of the managing committee can always move a motion of local.
Officer, no, it's an officer is what they say, the expression, no? The election to that office shall cease to be. Election is held.
That is only that definition. Officer, all the directors or their whatever name called, chairman, vice chairman, they are officers. No,
we are reading 73(1)(d), no confidence motion.
Let me please. And you have to finish this. Once the members, the primary members elect the managing committee, there are fixed number of seats. In my case, there are only 21 members for whom the primary members vote. Once that election is over, we were in minority. We also contested all 21 posts, but we lost in other only 5 seats. We were elected, and 16 is the majority. Now, after that election is over, the registrar, they calls a meeting to elect chairman and vice chairman of the society. These elected members of the managing committee, they elect chairman and vice chairman. Every cooperative society, take a housing society or take a gram panchayat, where the members, when the general public, villagers elect the ward members, these ward members then in turn elect the sarpanch, up sarpanch, like that. So the sarpanch, and there is ward members. So one set of ward members cannot move a no confidence motion against another set of ward members. Only they can move no confidence motion against the chairman and vice chairman. There is no other provision in the act for a no confidence motion against. Now let me place this.
What were the positions that they were holding?
Directors.
Directors.
Members of the managing committee. Directors. They are called directors also.
They are directors.
Yes.
And they appointed as directors.
Not appointed. They are elected by the primary members. They are members of the managing committee, directors. And when a special meeting is called, after this election is over, one representative of the registrar also attends the meeting. There, whoever is in majority, he gets elected as a chairman and vice chairman. So now, let me place this provision 73(1)(d) Malad for my satisfaction. Kindly have 73(1)(d). Motion of no confidence motion.
Confidence motion?
Yes.
Shows the no confidence motion?
No, let me place this provision.
Shows the no confidence motion?
Yes, ma'am. That is page 79. Is the order, Malots? No, motion is page 64, Malots.
In my case, 4 January 24, no confidence motion is passed.
They are not able to express against the office bearers, not as directors, office bearers of the society.
They may be called office bearers like chairman, vice chairman.
No, okay,
yes,
right.
all
They
these.
have suffered, Just wait for a minute.
No, just
sit down.
Let me know.
Just sit down, please, Mr. Shivaji. Just tell us the basic. Don't get into the argument.
Yes.
Give us the basic structure of what it is.
There is a committee. The committee members are elected.
Have we understood the removal of no confidence motion is only as regards the office bearers and not the directorship?
As the office bearers, in this case, the office bearers are members of the committee. That is the office. The office is, they are members of the committee. And they are being removed or a no confidence motion.
How do they get elected?
By the members of the society. So the society elects members.
How many members
to the
are
committee.
there for the society?
In my case, 21. Of the society,
8,000.
8,000 members. They elect amongst
members.
Themselves. They elect
8,000. So 8,000 members elect.
How many members? Committee members.
21 members of the managing committee.
8,000
primary members.
Primary members.
Elect, my lord.
Elect how many?
21 members to the committee.
Okay, that 21 members are those what he has given.
Now, my lord, may I just show?
And they form part of the board of directors.
Well, they're used interchangeably. They're used interchangeably.
Broadly, you say 24 members are the board of directors.
Yes, they're committee of members or board of directors. Your lordship may use them interchangeably as the definition.
And tell us one thing, from out of the board of directors, what is the office bearer? Who constitutes?
These are all office bearers, my lord.
All of them become office
bearers.
Entirety become office
bearers. Yes, just see, my lord.
So how many office bearers? Which are the
21, my lord, in this example.
No.
21 in this case.
How can it be?
All the 21 are office bearers.
Kindly see page 11 has the definition. Page 11 of the impugned judgment, or I've kept the, my lord, I've got the act and rules.
I will give you example, my lord. I'm sorry to interrupt.
Let me just.
1 minute, Mr. Shivaji. Just come back.
Does my lord have section 220, the second definition at page 11? Section 220.
Which page?
Page 11 of, my lord, paragraph 7, page 11 and item 51.2. Paragraph 7. My lord has it?
Office means a person.
Lord, your lordship may just kindly see officer. Means a person elected or appointed by a society to any office of such society according to its bylaws, and includes any office bearer such as chairman, vice chairman, president, vice president, managing director, manager, secretary, treasurer, member of the committee. Correct, my lord? Now, member of the committee, what is committee is defined above that, section 2.7. Committee means the committee of management or board of directors or the governing body, etc., of a cooperative society. As my friend fairly said, my lord, these are officers. Correct? Now, the only question is, how is an officer to suffer a vote of no confidence?
The entirety of your board of directors are officers.
They're all officers.
Then who remains? The board of directors doesn't.
No, there is separate officers of vice chairman, as your lordship sees in section 220.
What is the difference?
They hold separate positions. My lord. In addition, in a company also, my lord, a board of directors might be a managing director. There might be a managing director. There might be a separate title of chief executive officer. So, my lord, now, if your lordship is satisfied that he's an officer.
So his argument is.
Yes.
That whatever name you may be calling them.
Yes.
So they all get elected.
Correct.
And it is not as if they are amongst themselves get elected to a further board of
no, they don't.
Further board or a further office.
They don't.
Committee
members are officers, my lord.
No confidence is, do they revert back to a member?
Of course, they remain members.
What members?
Of the society. Of course, they remain members.
So how many members are there for the society?
8,000, my lord.
Those are primary members.
Yes. Those are the only other members other than what we are talking about.
What he says.
No, my lord, can you just read 73(1)(d) slowly with me?
8,000 members. Elect. Fourteen talukas.
Yes.
14 talukas consist of 8,000 members.
That is in item 51, but yes.
14 talukas consist of 8,000 members.
Correct.
And from out of each taluka, they elect one member.
That is, my lord.
One member who gets who represents that particular taluka as a director.
As a member of
As
the
a director, as a director, whatever. The moment there is no separate election for directors, the moment he gets elected in a taluka, he becomes a director.
Yes.
So out of those 14 directors, coupled with 5 directors elected from reserve category, coupled with 2 more directors elected from their cooperative societies, all constitute 21.
Correct. And there may be some government nominee.
According to them, out of that 14,
no one can vote at the
majority of them can't come together and remove the minority by a no confidence motion.
That is exactly contrary to 73(1)(d). That is exactly contrary to section 73(1)(d), which, my lord, Mr. Jadav's client challenged the constitutional validity of and dropped that challenge in the High Court and said himself that officers can remove by the requisite majority.
Now read the clause.
Yes,
the president, vice chairman, chairman, secretary, and this whole wording is improper in the sense that there is no bifurcation. All of them become directors.
All become officers, my lord. I'm sorry.
Office?
I'm sorry, my lord.
They don't become
I'm not
office bearers.
interjecting when your lordship says.
Tell us the difference between the officers and directors.
The directors are also officers. But
Who are the officers other than directors?
No, the vice chairman, the chairman, a secretary, treasurer.
Then go further.
Or any member of the
committee. Or any other officer, as may be, right?
Yes.
And for that you see the earlier definition. Officer.
Yes, 220. So now
therefore the whole thing is all officers.
Can you just see 73(1)(d) for a minute, and then perhaps it will become clear what the issue is, my lord. 73(1)(d) is also extracted at page 11.
Allow me to please.
An officer who holds office by virtue of his election to that office shall cease to be such officer if a motion of no confidence is passed at where? At a meeting of the committee by 2/3 majority of the total number of committee members who are entitled to vote at the election of such officer, and his office shall thereupon be deemed to be vacant. So what it says, my lord, is that at the committee meeting, 2/3 of those members were entitled to vote
You have challenged the constitution.
and dropped it, my lord. My lord, I'm sorry, and dropped it.
Give me 5 minutes.
At paragraph 4, you
let me
find
state
that.
my case. My lord.
And in his
Sorry, I
writ
was not
petition-
here.
In his writ petition, he says the section as it reads permits votes of no confidence to be passed at meetings of the committee of members. And he challenges the constitutional validity. And Lordship will see, my lord, at paragraph 3.
As it is, it seems to be permitting it.
Exactly, my lord, and that's exactly the point.
Officer holds.
Ultimately, my lord, as I started by saying, your lordships are interpreting the section. The section permits a certain procedure.
We need to know the difference between an officer and.
That's the point. Para 9 onwards.
I'm sorry.
And-
Everybody. So therefore,
these
one can vote against one another. Majority.
Sir.
That's it. Yeah.
at the committee level.
So it is.
And my lord, I'm sorry, I'll just say one more sentence, my lord, because I'll just say one more sentence. My lord. The rest of the scheme of 73(1)(d) explains who is to send the requisition, what is the period of no confidence, and the rules also, which are extracted by the High Court at the next page, supplement that. And all of them, my lord, speak that the committee can call a meeting and by the requisite majority can pass a vote of no confidence. And I was only showing that one sentence from the High Court judgment at page 7, paragraph 3. They challenged, my lord, Justice ARADHE has, my lord, the bottom of page 7, the last 3 lines. It is also necessary to note that challenge to the constitutional validity of the provisions of the Act as raised was same was given up, which stands recorded in the order. So your lordships have to, in my respectful submission, only read, my lord, 73(1)(d).
But you know the last verse, you know the rather
Sorry, my lord?
drastic, saying that the election members, one will, okay, you read, we'll just read the High Court judgment.
Yeah,
Yes,
this
Mr.
is
Shivaji.
provision again, my lord. Let me clarify. My lord.
Tell us.
Lordship wanted to know what is the office bearer. In this, my lord.
Use the mic.
My lords, take an example of SCBA. We all, my lord, the members of SCBA elect, my lord, the executive committee.
Shivaji, read
No, but
the
just
rule and
office
say,
there. No. And
don't
then
be sitting in panchayat. Just open the rule and then read the rule.
I'll 73(1)(d).
No, read,
Can
just read.
I show?
No, read the rule. That much we understand.
Yes.
That's the reason why we are asking him.
An officer who holds office by virtue of his election to that office shall cease to be such officer. Who holds office by virtue of his election, like chairman, vice chairman, to that office shall cease to be such office if a motion of no confidence is passed at a meeting of the committee by 2/3 majority of the total number of committee members who are entitled to vote at the election of such officer. Kindly mark these words. All the other members are not entitled to vote at my election. The general body is entitled to vote. Because chairman, vice chairman, because we are entitled to vote.
Which is the office you are talking about?
Any managing office bearers.
Which is the office? On the one hand, the argument is the moment you get appointed to a director, to the post of a director, automatically the office constitutes the definition of your office. So you will have to go up.
They may be called all managing committee members may be called officer. All the directors may be officer. But this how we
read.
Yes, my lord.
Officer is defined there.
Yes, my lord. Means a person elected or appointed by a society to any office of such society according to its bylaws and includes any office bearer such as chairman, vice chairman, president, vice president, managing director, manager, secretary, treasurer, member of the committee, and any other person by whatever name called, elected or appointed under this act. Just because there is a 220s, there is definition of officer is there. But this,
we understand you have very rightly challenged the constitutional validity of section 73(1)(d) because, as you are saying, one member elected, some members elected cannot by virtue of majority move a no confidence
Yes,
motion and
whether-
remove the other
whether
members.
they are
But then
entitled
what
to
the
vote
rule
at,
section is like that.
whether they are entitled to vote at the election of such officer. This is specific provision, my lord, for no confidence motion against the officer. That is the office bearers.
Well, you know.
My lord, what meanings, my lord, with respect, my lord, what meaning we give to this line? This,
You read para 12, from here we'll read at least.
please, my lord.
You're all arguing in the air.
So section 73 1D also uses the expression who are entitled to vote at the election of such officer, based upon which it is contended that such motion of no confidence can only be considered by the constituency or electoral college from which the officer member can be elected. We, however, find that the said expression has to be construed and understood in light of the scheme and purpose of the section 73 of the MCS Act is enacted. So the provisions of the and rules is clear, specific, indicate intention of legislature that motion of no confidence of any officer has to be requestioned, considered and passed or rejected in the special meeting of the committee. The aforesaid expression will have to be read in harmonious and purposeful manner, in consonance with the intent and purpose for the removal of any officer of no confidence motion. Milord, this time, Milord, how, what, Milord, the interpretation we give to this? Who are entitled to vote at the election of such office? Only by those members who are, Milord, when we were removed, when the no confidence motion was passed against me by other 16 majority members, whether they were entitled to vote at my election as a director, only the general body. This is the specific provision for the no confidence motion against the office bearers, my lords. There may, well, anytime you can pass, my lord, the no confidence motion against the minority members, and you can do any, my lord, the wrongdoings.
Let
And
the assembly,
yes,
not the court, to amend your rule.
but this provision is clear, my lord. Only by those members who are entitled to vote at the election of such officer. These 16 members are not entitled to vote at my election.
You just can't be, don't argue blindly. He's explained everything very clearly here. There is no question of a primary membership selection. They are talking about election in the context of 73(1)(b).
May I just submit, Manoj? This discussion is not divorce the bylaws, Manoj. That is what I wish to point out, because that representation of the talukas or the primary credit societies, cooperative societies, that is not taken note of, because statute will have to be read in the light of those bylaws, Manoj, and each bylaw is specific to the respective society. I'm sorry.
Page 19. You have, why did you give up your challenge? Why did you give up your challenge? I think that is where what the High Court did is it has interpreted the provision in the context of reading it harmoniously.
Harmonious would be.
Maybe you would have had a point to challenge the constitutional validity of the section. But the way it is formulated, it enables, it actually, you are right. The very purpose of democratic election is lost because it enables other elected members. It always happens. You can expel a member. The majority can always expel a member. You don't need to go back. But then the way it is formulated is like that. I think
may I just point out?
Okay, all right.
Just one
Leave it at that.
Here, he has given up not so far. I was concerned. Divisional registrar held in my favor specifically, and High Court allowed the writ petition on based on this fact. That is my specific case, because my case specifically, the bylaws specifically provided for that representation, but that is not taken note of. He may have given up that challenge in particular, but before the High Court, I was for the respondent, my lord.
You were for the respondent?
We were for my connected for the respondent, my lord, because divisional registrar specifically held in my favor and rejected the no confidence. That is the distinguishing feature so far as
And
your interpretation of the section clearly
my lords,
but you were a respondent in that.
We were respondents before the High Court, my lord, in the connected writ petition. And in the light of that and the fact that my lord, my bylaws were not specifically taken note of because I was in the connected petition, my lord. Therefore, may I also try and make out a case for remand, my lord, in that.
Your bylaws will not make a
My lord,
difference. It's a question of interpretation.
My lord, interpretation, my lord, but may I just point out, my lord, 73 1D will have to be read with the bylaws. There are judgment of your lordship, my lord, because every society is classified. It's specific, my lord.
You won't control the section, but you can take the flavor from the bylaws.
Lord, my lord, it has to be in that spirit specifically, in terms of the bylaws. And therefore, may I try and endure, my lord,
All
that
that will grant leave, will be real, leave
Yes,
granted,
yes.
leave granted. Hearing because it's an election matter.
Please, my lord.
Hearing
I'm
expedited.
grateful. Order, good luck.
All right.
My lord, my lord, so we are continuing on the body, my lord.
Yes.
Interim order may be continued.
All right. Yes. Next.
Grateful.
That's the interim order in item 51. Jadhav appeared in 51.
There is no interim order in the other.
Only in item
It's
51.
only in item 15, my matter. Lead.
51.2 is a separate society.
That we have granted it.
Yes.
Their term is about to end in next 7 months.
Whatever.
Although we are only on the question of interpretation.
Grateful.
Obliged.
I'm seeking an adjournment in this matter because the council appearing in this matter is then next in another court.
Shivaji, what is it?
Lord, I would pray that if your lordships can keep it on 24th, because I have some personal difficulty on the 10th, either on the 24th or on the 17th.
Terminate unauthorized leave. New teachers.
Lord, I have been continuing in that school for the last 30 years. I'm a cancer survivor.
So that your term is over. Okay, all right. Adjourn at the request. You 12 years you continued from.
Yes, my lord.
From the date of termination 7 years and from.
Yes, my lord.
Director's order 8 years.
My lords, I have worked there for another 7 years, my lord.
Why can't
My
we
lords,
have
I have
that?
worked for.
Why can't we?
Sorry, ma'am.
Why can't we dispose it of? We'll hear you.
Ma'am, sir, the respondent 5 is here. State, I am for 1 to 3. For the state, I am here.
Because the state has been throughout supporting me in the High Court, as well as a counter has been filed here also.
Yes.
It's a private educational institution.
Sir,
What
state
is
has
very
a minimum
small
role in
issue, my
this.
lord.
You are the employees. Tell us, tell us.
My lord, it's,
What happened? You were appointed as a Hindi teacher.
yes, my lord.
Then
Lord, can I just hand over a short list of dates? Because this would make it rather clear.
you went on leave in July and terminated.
I just hand over this list.
And some other teacher was appointed from, my God, the 2008 onwards.
My lord.
You worked initially for 12 years, isn't it?
No, my lord.
From
I worked.
2000 to 2008.
Yes, my lord. From 1996.
Then you were terminated in 2008.
My lord, that termination order was never given to me.
Never. Matter, you were out of service. From 2008.
Oh, my lord.
Then you filed
Yes,
an
my
appeal.
lord.
Yes, my lord.
Director
2013, my
reinstated you in 2015.
Yes, my lord.
So therefore the gap of 2008 to 2013, 2015.
15, my lord.
Is a gap. Then after the director appointed you, continued for another 8 years.
Yes, my lord. And I'm continuing because of your lordship has granted a stay also.
And a single judge
Yes, my lord.
quashed the order of 22-1. So therefore, you lost out there. Then you lost before single and division bench.
Yes, my lord.
Tell us one thing. From 2015, when the single you had an interim order, no?
Yes, my lord.
Directed reinstatement. They reinstated you.
Yes, my lord. And in fact, in 2017, I was granted aid by the state government.
But we granted you stay, is it?
Yes, my lord.
Is he? Who
Yes,
is
my
appearing
lord.
for the state?
My lord, they are appearing for the state.
Is he continuing service?
Yes, sir. She's in service.
But why don't you regularize her? She's a teacher.
Yes, my lord. And
So it's
the
a
government.
candidate post, my lord.
Then why don't you regularize her?
Well, it's a private educational institution,
Yes,
so
sir.
there's no question of any regularization by the government.
Niranjan Sahu is for whom?
But he's for the
My lord,
private
I am
one.
for respondent number 5. I am the one who was appointed in 2008, my lord. I continued from 2008 till 2015, my lord.
Are you continuing?
No, man.
My lords, now that my lords has already stayed the order, and in between the management has gone to the High Court challenging the order of the director, saying the director does not have the jurisdiction, my lord.
Why don't you consider both of them in the table? In the meanwhile, this lady appointed after the termination, is it?
Sir, there
In
was a
2008 to perhaps
Well,
2015.
there's a history to this case for which I handed over the list of dates. I was appointed in 1996.
Correct.
And from 2007, February 2007 to March 2007, I was suffering from cancer. In spite of that, I went to the school. They did not permit me. I wrote a letter to the director stating that the principal comes to my house and says that you resign, we'll pay you something and settle the matter. I went to the school. I taught the children.
It's all right. Children also will suffer. You are telling about yourself.
Yes, ma'am.
What happens to the school? You don't go to the school.
My lord, I went to the school. Your lordship will just have a look at the letters. I have
From
written.
2007
My lord,
onwards.
I have written letters. That's a wrong thing. Now, none has been considered.
Anyway, 2008 you were terminated.
My lord, I don't have the termination order. The termination order was.
All drama.
My lord, the termination order was passed and it has been
Anyway, you
recorded
were
by the
directed to be
director.
reinstated only in
My lord, the
2015.
director records that there was no termination order. Nothing was issued on me, and pursuant to which I was reinstated. The director records that. And on that basis, I was reinstated. I'm a widow. I suffered.
Still in service or retired?
I'm still in service.
How
my
much
lord.
more?
I have about 3 or 4 years left. 3 years.
3 years. Yeah.
And I'm surviving because of my own income. My husband is dead.
In between, I am the one who is at the receiving end, my lord. Despite
You
serving
worked
for
from
7 years with the
2018.
school.
You worked for 7 years from 2008 to 2015, is it?
Yes, my lord. Yes, my lord.
That's the only period.
And
But
because of the court orders, I was
only
not.
one thing is, Mr. Niranjan Sahu, your
Yes, my
client
lord.
has not been working since 2015,
My
whereas
lord.
he has been working from 1996 till date, except for that period of 2008 to 2015. That's the only difference between both of you.
My lord, the responsibility lies solely on the authorities, my lord.
But you are appointed as a stopgap.
No, my lord, I was not appointed as a stopgap appointee, my lord. I was appointed. My appointment is not in challenge. Rather, her termination is at challenge, my lord. What has been done, my lord?
हो जाएगा एडमिट कर देंगे एलो करना है but concurrent fine who's concurrently Mr. Shivashish?
Yes, sir.
Why did you lose by both the courts concurrently? Why did they?
My lord, they said that I have abandonment. It amounts to abandonment of service. That is the finding of the learned single judge. I never abandoned
Let's see
your
the High
lordship.
Court judgment division bench.
Can your lordship just have
Let's see the
one-
impugned order.
My lord. The impugned order is starts at
Page 6. Page 6.
3.
Assailing the impugned. Okay, there. Para 8. You see, single judge allowed the writ petition. Allowed, is it?
Allowed the above writ petition because they challenged the director's order.
So the respondent number 5 has challenged
The school
And the
and
management,
the private party, both of them filed 2 writ petitions before the High Court.
Yes.
And my appeal before the director was not for termination because I didn't know that I was terminated. I went there to say that I'm not being allowed to function in the school.
Who is appearing for the school?
Look, someone is representing, but no one is appearing. Lord, could your lordship just have a look at page 37? My first letter.
1 minute, to complete. Yes. I've seen it. In other words, 22nd January. In other words, government stand can be seen by virtue of 22nd January 2015 order,
Yes,
which directs that you should be
Could your
appointed.
lordships have a look at the
Huh?
The basis of
That
the
is the
case.
basis of your case. So you will stand by that order,
Yes, my lord.
which means that you will support him
Yes, my lord.
fully.
Lord, just have a look at.
We'll go by the government. We'll go by the government order.
Very well.
Okay, leave granted, leave granted.
My lords, may hear me, my lords.
Yes, yes, tell us, tell us.
Now, my lords, I was appointed, my lords, I was appointed in the year 2008, my lord. Thereafter, the appeal against the so-called removal from service or termination, my lord, whatever my learned senior says, comes in 2013, after 5 years, before an authority which does not have the jurisdiction. Admittedly, my lord, the jurisdiction is a creature of statutes. They take away the jurisdiction in 2002.
Which statute?
This is with the regional director.
Where is this
And
22
on these two
115 order?
Lord, at page 43.
What's the relevant portion of that?
Lord, if your lordship will turn over to 44. The second paragraph, the district education officer Puri reported that the appellant has performed her duties till 1/3/2007, but she remained absent from 12/2 so-and-so and from so-and-so without any intimation. She remained absent unauthorizedly again with effect from 2/4. The school authorities issued notice to her asking, this is the contention of the district education, this is the contention, their contention. And your lordship will look at page 44, last paragraph. At the time of hearing, the headmaster of the school appeared on 6/12/2014.
Leave granted.
My lords, I was not made a party, my lord. First of all, my lords, I am not a party before the director.
What do you mean?
And this order has been
Anyway,
passed against
you
me.
challenged it in the writ petition. We have seen that. Okay, we have heard you now. Leave granted.
My lords,
Petitioner was working
I may
as-
be protected, my lord.
was working as a Hindi teacher in respondent number 4 school. In the case, it is a case of the petitioner that she had applied. No, petitioner joined service on 4/10/1990.
96.
1996 as a Hindi teacher in Hindi teacher, full stop. ऐसा लिखिए ना, we'll start from beginning. Petitioner was employed as a Hindi teacher on 4/10/1996 in respondent number school. It's the case of the appellant that she had applied for leave in the month of February 2007 for 17 days, and subsequently in the month of March again for 18 days. And after availing such leave, she attempted to submit her resignation. However, the same was not accepted by respondent number 4. Paragraph respondent number 4 has thereafter issued a letter on 22/1/2008 terminating the service of the petitioner and appointed respondent number 5 as the Hindi teacher on 6/12/2008. The petitioner thereafter made a representation to the district education officer from a respondent number 3, contending that she has not been allowed to join. The petitioner also approached the director, secondary education, Orissa, on 1/11/2023, making a similar representation. By order dated 22/1/2015, these are order, 22/1/2015, the director of secondary education, Orissa, passed the following order. Please quote this order from page 14 onwards. The district education वो सब लेकर जब quote करके अब mark here A. Yeah, the quote children. In view of the above, the director passed an order directing the managing committee, Levan Satyagrah Samaj so and so, to take back the appellant in her former post as the Hindi teacher of the school, and further recommended renewal. All higher authorities recommended her name for renewal recognition from, I don't know, what is this renewal recommendation form?
Lord,
The
every
moment she
time,
takes back, is it?
every time a renewal recognition form is sent to the state, to the state, with regard to the employees of a private aided educational institution.
The director
My lord, what happens is, my lord, the government
recommended her name for renewal recognition to the higher authorities. After questioning the above said order, respondent number so and so filed a writ petition before WP number 5612 of 2025, or respondent number 5, before the High Court. Two writ petitions he has filed, writ petition number 5612 of 2015 and writ petition number 3231 of 2015 before the High Court. Both the writ petitions were taken up and disposed of by the learned single judge of the High Court by his order dated 22/1/2015. The writ appeal filed by the appellant came to be dismissed by the order impugned before us. We heard Mr. Sudashish Mishra, learned counsel, appearing on behalf of the petitioner, and Mr. Where is the brief? Brief का है? Brief क्या? Prakash?
Sir, I'm Debashish Jena. Prakash Jena is a AOR.
Okay. Debashish
Jena.
Jain.
Jen. Jena.
Jena, representing Prakash Ranjan for the state, and Mr. Niranjan Shahu, advocate on record for respondent number 5. Having considered the then you cite, it is an admitted fact that the appellant was appointed in 1996 and continued in service till 22/1/2008, 2008, except for the short duration when she is supposed to have been unwell. Further, by virtue of the orders passed by the director on 22/1/2015, which we have extracted here in above, appellant continued in service thereafter, even during the pendency of the writ proceedings before the single judge as well as the division bench. While issuing notice on 17/1/2004, we have also granted an interim order by virtue of the order dated 22/1/2015 and the order passed by this court. The petitioner was in continuous service from 1996 till date, except for the short duration between 22/1/2008 and 22/1/2015. There is no doubt.
She was missing from 2007, my lords. So should we?
2007, but your order of termination came only on 22/11/28. She might have been on leave, but you didn't terminate it. Okay. In this view of the matter, we are of the opinion that the petitioner's services must be confirmed. We, however, make it clear that the petitioner may, will not be entitled to back wages for the period 2008 to 2015, except that she will be entitled to continuity. She will, however, be entitled to continuity of service. So far as respondent number 5 is concerned, the appointment, his appointment, when was it appointment? 2008, right?
Yes.
Yes, my lord.
6/12/2008. 6/12/2008 to 2015. 2015 is should be treated as an appointment. Be treated as an appointment which has not been confirmed and during the pendency of the proceedings. How will you justify his? But that's a termination order. That respondent.
My lords, may I submit few? My lords,
you are out of service, Mr. Niranjan.
My lords, I have been because of the court proceedings, my lord. Otherwise, my lords,
we are reversing the order.
Now, my lords, at least what has happened, my lord, just listen to me for
what we can give you. Don't argue the
Yes,
case.
my lord.
What is it that we can
Yes,
do?
ma'am.
From 2015, what are you doing? You just say
My lords,
like
I am waiting for the outcome of it. My lords, I have two daughters, my lord.
For the services that she or he has rendered from 6/12/2008 to 22/1/2015, she or he will be entitled to complete remuneration for the said period. Complete remuneration for the said period. On number 5, right? Complete remuneration for the said period. This is do justice because the appellant is been working continuously, and yours is anyway 2015.
Some compensation may be awarded in such. If that is the case, my lord, if my lord may consider giving us some compensation, my lord, at least.
Who will give?
Because I have not at fault, my lord. It would be my lord state.
Shivashish Mishra will give some compensation to her.
I am a widow. I am a cancer survivor.
My lord,
Where
I
do
have got two daughters. I have got to get them educated.
Public services, sir. What can be done?
My
state is at fault, my lord.
I'll just point out that the second line.
Their DI says that
private
I was working.
Lord, in the second line.
We can't blame anyone.
My lord, in the second line, your lordship has stated that I offered my resignation. It is actually my joining report.
Yes, my lords. There was no.
I did not give my resignation. It was my joining report, which was not accepted.
Okay.
Very
your joining report was not.
Yes.
Sorry, we said that.
Not mention item 27, my lords. Item 27.
Note कर दिया ना?
Item 27, my lord. There's some urgency. If it can be listed next week. These matters will not arise out of recruitment process. Short date next week. My lord. Item 27. Specially fixed.
27?
Yes, my lord. Today's board.
We'll come on Tuesday.
Not 46, may I request, not week after.
31.
Not in 46, not week after, if possible.
Will come on Tuesday. If you don't want, please mention.
Not 10th in 46.
We want to file a convenience compilation in furtherance to the direction of the note. We had to file a brief note. We have done that. We want to file a convenience compilation.
After